Okay, welcome today to Piercing the Corporate Veil in Nebraska. Welcome. Our speaker today is Peterson of Wolfe Snowden in Lincoln, who practices in the area of commercial and business litigation, business planning, and commercial transactions. He obtained his Juris Doctor and Master of Business Administration at the University of Nebraska. Chris has experience litigating complex commercial disputes, including requests to pierce the corporate veil in both state and federal court. So please welcome Chris.
Good afternoon. As we mentioned, this is a CLE on piercing the corporate veil in Nebraska. I wanted to give you just a short background on myself. I'm an associate with Wolfe Snowden. I have some experience litigating many of these issues, and I noticed some confusion beyond just the standard confusion regarding piercing the corporate veil that we learned about in law school. I noticed Nebraska had especially confusing veil piercing jurisprudence, and so I did what I believe any reasonable attorney in Nebraska would do under the same or similar circumstances, and I wrote an article that will be published in the Creighton Law Review in March of 2018 called Piercing the Corporate Veil in Nebraska. So much of what I'm going to discuss today is coming from my findings in that article, and so I just would draw your attention to that and in that forthcoming article. So the state with perhaps the most confused veil piercing jurisprudence is Nebraska. So, you know, we may not be number one in the gridiron on Saturdays, but we can at least say that we're number one in having the most confusing veil piercing law in the country. And so, as kind of a background, my article consisted of reviewing a little over 120 published and unpublished articles in Nebraska. I found 3 separate avenues for piercing the veil, and also found cases that discussed some collateral issues, including reverse and horizontal veil piercing procedure, piercing the LLC veil, the defense of estoppel, and different standards that might apply to different categories of creditors. Finally, is the role of fraud in Nebraska's veil piercing law. So as a background to my remarks, I want to emphasize that courts are continually referencing established principles of equity as kind of the backdrop for their veil piercing opinions. So if we think generally about equitable matters and how courts resolve equitable matters, their primary goal is to do justice, and this is often to mitigate rigid, strict legal rules. But also, those established maxims of equity will also apply. And so I have here 5 maxims of equity that are general for all equitable type of actions, but that are especially relevant in the veil piercing context. So equitable relief is available only where there is no adequate remedy at law. Equity regards as done which ought to be done. Equity looks to the intent rather than to the form. Equitable relief is extraordinary, not ordinary, and equity only helps those who have done everything to help themselves. So the first case that introduced what I call the 4-factor test was in 1980, the case of United States National Bank versus Rupa. And the way that Nebraska courts will often analyze a request to pierce the veil is they'll first list the primary justification for piercing the veil. And so that kind of justification takes the form of preventing fraud, preventing other injustices. The court has also stated that that the veil might be pierced where necessary to prevent, when the corporate entity is used to defeat a public convenience, justify a wrong, or defend crime. So there's a variety of these justifications that the courts are using. And what the court began doing in this 1980 case of RUPA is it attached certain factors that help almost prove these justifications. So in RUPA, the court stated some of the factors which are relevant in determining to disregard the corporate entity are, and it lists these 4 factors. Factors include grossly inadequate capitalization, insolvency of the debtor corporation at the time the debt is incurred, a diversion by the shareholder of corporate funds or assets to their own or improper uses, and finally, the fact that the corporation is a mere facade for the personal dealings of the shareholder, and that the operations of the corporation are carried on by the shareholder in disregard of the corporate entity. So these are factors, again, that are stated as support for piercing the veil, or naturally, they would be support for those primary justifications for piercing the veil. And it's very much a balancing act of finding evidence of each of these factors and then weighing them to determine whether one of those justifications have been met. And it's also important to point out that this 4-factor test didn't remain the same, or I guess it was modified slightly about 6 years later in J.L. Brock Builders Incorporated versus Dahlbeck. And this Dahlbeck standard that was established in 1986 is really the standard that the court has been following at this time. And you know, as we get into this, I just want to reference or mention again that if you have questions at all during the course of this presentation, don't be afraid to let me know. We've got several individuals here in person, and then that are watching this via webinar. Mr. Brenner asked this question here: is the treatment of LLCs different than piercing a corporation? If different, how so? And I just want to let you know, we will be getting to this later, but in short, the standards are the same with one exception, and that's going to be with that 4th factor relating to the corporation is a mere facade, because as you'll see, corporate formalities are an important sub-factor in proving that 4th factor. And as we know, LLCs are not required to adhere to the formalities that corporations are in terms of holding annual meeting of the shareholders and directors and keeping track of those meeting minutes. And so that's going to be the primary difference, is that in LLC veil piercing cases, you will not see reference to whether or not those corporate formalities are being followed. So with Dahlbeck, the main difference that Dahlbeck presented in comparison to RUPA is now it used, or it attached those 4 factors, instead of just being general factors that are the court will review to determine whether to disregard the corporate entity. It now states that those factors are relevant to determining whether to pierce the corporate veil on the basis of fraud. And so there's a shift in the Supreme Court's use of these factors. Now it's a focus on fraud. And as I just mentioned here in the previous slide, we know that fraud is not the only justification for piercing the veil. But now, beginning with Dahlbeck, these factors appear to be connected with the idea of fraud, which is, in my opinion, a heightened standard for plaintiffs to satisfy. We see here a number of other justifications, yet the court begins to focus on fraud, and that these 4 factors are, as it refers to it, as badges of fraud, and that a single factor may establish or stamp a transaction as fraudulent. To put this case in context, just a few months prior to Dahlbeck, the court had come out with the opinion Service Masters Industries versus JRL Enterprises, and this analyzed the plaintiff's veil-piercing claim under a standard of fraudulent misrepresentation, which requires proof of civil fraud, actual fraud. And as we know, actual fraud has this intent requirement, this scienter requirement, which is an exceedingly high standard. And of course, there's no surprise that the plaintiff was unable to satisfy that high standard of actual fraud in that case. And so several months later, it comes out and revises the RUPA standard and focuses those 4 factors as evidence of fraud. And we see that in subsequent cases, that the court references those 4 factors as relevant to disregarding the corporate entity on the basis of fraud. So I consider the Dahlbeck standard kind of this revised 4-factor test. So let's go through each one of these factors, and beginning with the first factor, inadequate capitalization. So how is the court defining inadequate capitalization? Well, they define it as capitalization that's very small in relation to the nature of the business of the corporation and the risks entailed. It is measured at the time of incorporation. The court has also stated that in and of itself, inadequate capitalization is insufficient to pierce the veil. So more is needed. And again, I referenced in Dahlbeck, the court discussed these 4 factors and stated that a single factor could be enough, but that's not the case just with inadequate capitalization. With the rest of the factors, according to the court's opinion, again, if that factor is considering the facts and circumstances of the case, one factor may be sufficient. As far as insolvency, we look at the time of insolvency as being when the debt was incurred. And insolvency is defined as the corporation being unable to pay its debts as they become due in the usual course of its business, or if it has excess of liabilities over its assets at fair valuation. So there's 2 different standards here for insolvency. The third factor is the diversion of assets by a shareholder for his own improper uses. Shareholders of insolvent corporations, they can't participate in distribution of assets until claims of creditors are paid. Again, so if you see shareholders diverting those assets at the, with creditors being harmed as a result of that, assets are unable to pay creditor claims because shareholders are paying themselves first or transferring assets to themselves or to affiliated corporations, then that would satisfy this third factor. And the fourth factor is, again, the corporation is a mere facade for the personal dealings of the shareholder. So often this is looked at as kind of the mere shell mentality. So if the corporation is created as a mere shell, has no legitimate business purpose, apart from being kind of an intermediary or to try and defraud creditors. This factor is often referenced in context of a shareholder's control over the entity. So in Dahlbeck, the court stated when one is in control of a corporation, or excuse me, whenever one in control of a corporation uses that control or uses corporate assets to further his or her own personal interests, the fiction of the separate corporate identity may be properly disregarded. So it's this idea of control, and that's where you'll see in a number of these cases what I consider to be sub-factors of the fourth factor, or specific facts and circumstances which show this control of the corporation by the shareholder, and that such control shows that the corporation is being used for the personal interests of the shareholder, in disregard of a separate, distinct corporate identity. So first question I want to, more rhetorical than anything, that I want you to consider is, should courts be limited to just these four factors in evaluating veil-piercing cases? So in other words, should this be a straight factor test to pierce the veil, or should the court be allowed to entertain other facts and circumstances that might assist it in deciding whether one of those primary justifications that we talked about earlier have been satisfied? So we know that veil piercing is an equitable remedy, and I want to point out that although Nebraska courts will typically focus their opinions on those four factors, those opinions also seem to leave the door open for the court to consider additional facts and circumstances. So in each of these cases, it discusses how how the four factors are some of the factors relevant to determining whether to disregard the corporate entity. And in the context of equity, it discusses how the whole transaction should be examined to look through the corporate forms to the substance of things. So again, this is one of those equitable maxims, but the court is stating that the entire transaction should be examined to determine whether the rights of innocent parties need to be protected or fraud needs to be circumvented for the protection of those parties. And I see this as more of a totality of the circumstances test, where these factors are kind of the primary point of review for the courts. Those are the first things the courts are going to look at, but it doesn't necessarily mean that other facts and circumstances can't be taken into account. And you look at several other jurisdictions and some of the factors that they use, and there are some specific factors that other jurisdictions use that aren't explicitly stated as one of the four factors in Nebraska, but which, under the right circumstances for a specific transaction, there's an argument that those could also be relevant in piercing the veil. The next issue is fraud and what role fraud plays. We discussed how that Service Master's case required this idea of actual fraud, which is a incredibly heightened standard, requiring plaintiffs to to satisfy. And so is actual fraud required? Was that just a one-off case, or is that the standard in Nebraska? And you know, I'll I guess pose what I found here. You know, according to Dahlbeck, a single factor is often all that's necessary to establish a transaction is fraudulent. So we see this focus of these 4 factors on the idea of fraud, and that each one is a badge of fraud. And first here, most jurisdictions accept that morally culpable conduct short of actual fraud satisfies veil-piercing standards. Nebraska courts allow it to prevent fraud or other injustice. So again, we talked about these other justifications. It's not just to protect fraud. That isn't the only justification. We see violate a legal duty, perpetrate a dishonest or unjust act. I mean, the idea of injustice or wrongs that have been committed is often referenced by the court. So I don't believe actual fraud is necessary. And I think some of the confusion in Nebraska cases perhaps have come because we don't know, well, you know, is actual fraud required or not? But again, pursuant to these previous opinions referencing these other justifications, I think there are plenty of arguments to state that actual fraud isn't required. More of kind of a constructive fraud standard, I think, would be more appropriate, considering again sort of these other justifications which don't rise even close to the level of actual fraud. So when a principal shareholder appropriates and uses corporate funds and property for his personal purposes and therefore defrauds and causes damages to creditors, the shareholders can be individually liable for corporate debt. So this now is well, let me back up. This was cited in Christian versus Smith. And this was as the court was going through the 4 factors and citing support for those 4 factors. And one of the cases that the court cited for support here for the 4th factor was this case from 1979. Again, this is before the 4-factor test even came about, in Scribner, Grain, and Lumber versus Wortman. But here the court is almost, I mean, when you look at this statement here, this is, and my contention is this is going to be a separate avenue for piercing the veil, apart from the 4-factor test. And that would be the diversion of assets by the shareholder for their own personal use. And we see not only here in this 1979 case of Scribner Grain, but we see from there, and what I've noticed is that any time this 3rd factor, the diversion of corporate assets, is satisfied, then the court always pierces the veil. So it kind of started with Scribner, and I think that's what was the basis for the 3rd factor in and of itself, but shows that the 3rd factor really is an independent avenue for veil piercing, and there's substantial support for that in the Supreme Court opinions. So just as a background here, Scribner involved a plaintiff corporation obtaining a judgment against the defendant corporation, which is a commercial feedlot, for non-payment of bills relating to cattle feed provided to the plaintiff. A judgment was obtained but went unsatisfied. The plaintiff brought a separate action to pierce the corporate veil. The shareholder had diverted about $12,530 from the corporation for his own personal uses, but that was a small amount in comparison to the revenue this company was generating. but there was another important way that assets had been diverted, and that was this shareholder. Not only did he have, private clients that he was overseeing their cattle and feeding them, but he had his own mixed in with those other customers, and he ended up charging his own cattle only a fraction of the actual cost of actually feeding those cattle. And so that the court found that was a diversion of corporate assets to his own personal use, his own personally owned cattle, and that as a result, it was held to defeat a public convenience, justify wrong, protect against fraud, or defend crime. So that was kind of the justification that was referenced by the court. So again, mentioned that again, in each case where the court found a diversion of corporate assets by the shareholder, that the veil has been pierced. Here's the second independent avenue, and I call this the alter ego standard. But if we go back to, let's see, well, I'll reference Christian versus Smith again, because Christian versus Smith did this with the third factor and with the fourth factor, where it discussed, it referenced these factors, but did it in a sense that making a statement that the fourth factor in and of itself might be used as an independent avenue for piercing the veil. And it cites some of these other cases. Again, this is a case, Hayes versus Sanitary Improvement District. This case came out before RUPA in 1980, so this is 1976, where the court states that there is precedent for the notion of separate corporate existence of parent subsidiary or affiliated corporations not being recognized, where one corporation is so organized and controlled by its business conduct in such a manner as to make it merely an agency, instrumentality, adjunct, or alter ego of another corporation. The fiction of the separate corporate identity of two corporations will not be extended to permit one of the corporations to evade its obligations or promote fraud or illegality or injustice. So again, it cites the justifications for piercing the veil and states that this idea of control, of alter ego, alone is sufficient to pierce the veil. And then, from here we see 4 years later, it shows up as the fourth veil piercing factor in the RUPA test and continues along in Dahlbeck as it's modified. But this and subsequent cases have established this as an independent avenue for piercing the veil. An excellent example of this is in 1989 Carpenter Paper versus Lake and Meat. The plaintiff corporation brought suit against the defendant corporation and its principal shareholder for breach of contract, fraudulent conveyance, and a request to pierce the veil. The court first analyzed the Dahlbeck factors, and most of those factors were inconclusive or unsupported. So the first three factors, the plaintiff was not able to establish those first three factors. However, and the court says this specifically, contrary to the factors in Dahlbeck, it decided to pierce the veil after finding that the shareholder had satisfied the fourth factor. And it stated that the shareholder controlled the corporation's every move and ran it as he saw fit. So here is a prime example of the fourth factor being the only factor that was satisfied, and the court pierced the veil based only on those grounds. This was again illustrated by the Court of Appeals in 2001, Graham Graphics. So here the plaintiff corporation sought to horizontally pierce an affiliated defendant corporation. Again, we talk about horizontal veil piercing as seeking to hold an affiliated company liable for the debts of the defendant. So it's not parent and subsidiary here, it's just affiliated corporations. So the court reviewed the Hayes alter ego standard for piercing the veil, and it didn't reference those Dahlbeck factors once. It only looked to that Hayes standard, that alter ego standard, looked at the control, the independence of those two entities. It held that that defendant corporation could be horizontally pierced to gain access to the assets of its affiliate, relying solely on that alter ego standard. So now that we have an idea of what those four factors are, we have an idea of two independent avenues for piercing the veil, I want to touch on how do we prove, especially this fourth alter ego fact. Well, the fourth factor, also known as the alter ego standard of piercing the veil. So what do courts look at to satisfy that alter ego standard? And so what I've done is I've pulled out a number of facts that the court has referenced in deciding or in deciding whether that fourth factor has been satisfied or whether the alter ego standard alone has been satisfied. So these, for the litigators out there, and also for transactional counsel, pay attention to some of these, because this is the nitty-gritty of veil piercing analysis. These, I consider these almost sub-factors, as we mentioned, that you should pay attention to. This is going to be a balancing test, and courts have noted that perhaps one of these sub-factors alone isn't going to be sufficient. So just because your client owns all the stock of the corporation doesn't mean that their veil is going to be pierced. It's in conjunction with a number of other factors, perhaps, that would tend to show that there is this control, that there's not a separation between shareholder and corporation or separate entity. So going through these, the corporation operated almost wholly on money from the shareholder. Shareholder diverted assets between the corporation and affiliated entities. Obligations incurred by one corporation were paid by another. The shareholder had interest in other corporations to which he permitted the corporation to extend credit. Employees of affiliated companies were the same. Again, this is another example of, just because there are employees that are the same doesn't mean the veil is going to be pierced. But in the context of other facts and circumstances, it could certainly be relevant. Significant personal loans made by the shareholder to corporation on a regular basis. The shareholder's security interest in company assets as a result of personal loans. Okay, so the shareholder is loaning money to the corporation and trying to secure his place in that collateral. And the repayment of personal shareholder loans following the sale of company assets. And again, that would be at the exclusion of creditors. Additional facts and circumstances here, we have operating under the same name, use of the same bank account, use of the same office address, use of the same books, records, and taxes, not following corporate formalities, so annual meeting of the shareholders and directors, and lack of other corporate records. So as far as other corporate records, I see that as corporate records that you would expect to see in independent corporations or arm's length transactions. If there are transactions between a corporation and an entity, do you see evidence of those transactions? Or are assets just transferred between the companies? So the more records that can document the transaction showing that it is an arm's length transaction, and there isn't going to be a a diversion of corporate assets as we saw in that Scribner case, then that's gonna help show separate identities. Okay. Here, let me repeat this question from Mr. Ellefson. If there are other shareholders who did not benefit from distributions to a shareholder when the entity is insolvent, of course, the receiving shareholder is liable, but is there liability to the other shareholders? And that's a good question. I haven't seen that in the case law as far as perhaps if there are multiple shareholders and one of them is the controlling shareholder and he's the one that is diverting assets, or he's the one that's perhaps kind of the control shareholder. I have seen some cases that to the effect, though, and it's the difference between a claim against a shareholder or an officer for fraud, okay, a civil claim for fraud, which you wouldn't need to pierce the veil if you're attacking a shareholder for actual fraud. There'd be no reason to pierce the veil because you satisfy the elements of civil fraud. However, I think there's an argument here that a non-participating shareholder might be held liable in this situation. Again, depending on the facts and circumstances, but I think there's an argument to be made that there could be some liability to that non-participating shareholder. And the idea of piercing the veil, that's how it's different, I guess, from a claim for actual fraud. So good question. And finally, we have a case here in 1993 where the veil wasn't pierced and the fourth factor wasn't satisfied. However, the court did list certain facts and circumstances which alone, it stated, were not sufficient to pierce the veil or to satisfy that fourth factor. However, naturally, these would be facts which, in conjunction with others, should be supportive of that fact. So just because the veil wasn't pierced doesn't mean that these facts and circumstances the court referenced wouldn't be relevant. So I see these as additional sub-factors. Ownership of all the stock by one person or entity, sharing of services between two corporations, guaranteeing of financial obligations between corporations, and interlocking of directors without evidence of manipulative conduct. Okay, so are there any questions about any of those three avenues of piercing the veil? So we have the 4 factors test, and then we have the third and fourth factor of that test used as separate avenues for piercing the veil. If there aren't any questions, I'm going to move on to some collateral issues. But and again, if you have questions afterward that you come up with, feel free to send me an email. I'd be happy to respond to those. So beginning with the first collateral issue is reverse veil piercing. And this was kind of a confusing concept for me to wrap my head around at first, but reverse veil piercing occurs when a third party seeks to pierce the corporate veil to impose liability on the corporation in order to satisfy the personal debts of the shareholder. So the primary context of this type of request would be in the dissolution of marriage context. So so one of the spouses wants to have the veil pierced so that she can have access to this separate corporation, for the debts of her spouse. I've also seen this in the context of workers' compensation, and this is kind of an interesting idea. It hasn't been successful, but I've seen it asserted by parties in Nebraska, and that's when defendant corporations seek to pierce their own veil so that the exclusivity of the Workers' Compensation Act would apply to the parent and the subsidiary. So say a parent owns the real estate, but the employee plaintiff is injured on that real estate as she's on the business premises, and naturally the subsidiary claims against the subsidiary are to be found in the Workers' Compensation Act. However, plaintiff tries to file suit against the parent for premises liability, and so the defendant would try and pierce its own veil and say, no, we're basically the same entity. Parent and subsidiary, we're the same, and as a result, the Workers' Compensation Act is exclusive. And courts have said no. This goes against those justifications of veil piercing, those equitable justifications, which is really plaintiff-centric to prevent these innocent third parties. So defendants, courts have stated that they chose to be separate entities and they need to live by the choice that they made. So we have a question here, one moment. Okay, if you're pleading fraud in a complaint, you do not need to plead veil piercing. It doesn't hurt to also, I would plead both of those. If you have support for actual fraud, I would plead actual fraud. But in the event you're unable to satisfy the strict requirements of actual fraud, veil piercing is going to be kind of your fallback. If you have an innocent member of an LLC, should you separately plead veil piercing in addition to fraud? I would say yes. Again, I would allege veil piercing every time in that context. If you have reasonable grounds to allege actual fraud in the complaint, I would, against the shareholder, I would put in a request to pierce the veil too, every time. Okay, horizontal veil piercing, we talked about that with the Graham Graphics case. This occurs when the court ignores the autonomous corporate structure of affiliated corporations and makes their assets available to satisfy claims. Nebraska does allow this. They stated it a number of times, and then Graham Graphics is the prime example of the court actually piercing the veil against an affiliated corporation. Collateral issue, the next collateral issue is equitable estoppel. This is one of the only defenses to veil piercing. And so I have here the elements required to establish equitable estoppel, but in relation to veil piercing, it's a little bit. I guess it's very narrowly viewed by the courts. The courts do allow it, and the prime example is a 1932 case. But plaintiffs have been trying, well, I guess defendants are trying to state that plaintiffs should be stopped from denying the existence or status of a corporate defendant because such plaintiff had known that it was dealing with a corporation. That was asserted here in Victory Lake Marine versus Veldius, and in this case, the court, there was an issue with a procedural issue. This defense was not asserted as an affirmative defense at the get-go, and so because it was not affirmatively stated in their answer, they were not able to bring it up at trial. So keep that in mind for defense counsel. If you think you have an estoppel argument, then allege it right away. And here's that limited scenario where equitable estoppel could be successful. And this is in the context of a corporation that that was initially organized properly, but that has yet fallen into expiration. That shows up in Secretary of State as as having expired, yet continues to transact business as a corporation and in its corporate name. So the court stated here in Lisco, when a party contracts with an imperfectly organized corporation, he is estopped to deny its corporate existence and is precluded from recovering from its members individually as if they were partners. Okay, so there's almost this feeling of assumption of the risk, if you may, that when a party is entering into a contract, and all these records of whether a corporation is active or inactive are public record, the plaintiff is going to be estopped from arguing that it should be a separate corporate, or that they should be one and the same in that case, because it was public record. They knew when they entered that transaction that this was an imperfectly established corporation. So I think the argument is there. I haven't seen it successfully asserted really since Lisco. Most of the arguments are based on the procedure and alleging it as an affirmative defense in the defendant's answer, and whether they did that or not. So veil piercing procedure. Question is veil piercing a cause of action, or is it a remedy? I think generally this is a remedy, but Nebraska courts appear to allow sort of this independent veil piercing cause of action to proceed. So this hasn't been litigated, but I'm seeing that plaintiffs are alleging it as a cause of action. Also, these claims may be brought after the plaintiff has obtained judgment and that such judgment has gone unsatisfied. We saw that in a prior case earlier today. And then a more recent case is Ickhurst versus Orthopedic Specialists, which is basically, again, a case where the plaintiff obtained judgment against the corporate defendant. In fact, the individual shareholder was listed as a defendant in that original action, yet he was dismissed as a party. And then after judgment was obtained, they sought to pierce the veil against the shareholder, asserting, again, the veil piercing claim. And the court allowed that case to continue because there were new facts that occurred, or that were established after the original judgment had been obtained. And that was the fact that the plaintiff was alleging that assets had been diverted after judgment was obtained, and that was sufficient sufficient new or additional facts that would allow this new claim to be brought, even though the shareholder had been dismissed from the original action. Piercing the LLC veil, we touched on this earlier, but just want to again emphasize that the same test is used. So courts are using that same 4-factor veil piercing test. The only difference is with regard to the corporate formalities. So we listed the adherence to corporate formalities as a sub-factor in the fourth veil piercing factor of that RUPA or Dahlbeck standard. And with relation to LLCs, that is not referenced at all. So courts are ignoring any mention of an LLC's observance of corporate formalities when deciding whether to pierce the veil. And that should be the case because Nebraska statutes are clear that corporate formalities are not grounds for imposing liability on members or managers for the debts and obligations of the LLC. With the remaining time here, I just wanted to touch on an issue that hasn't been addressed in Nebraska, and that's with regard to differentiating between creditors and whether different standards for veil piercing should apply to different categories of creditors. So on one hand, we have contract creditors, which are individuals that had a prior relationship or a voluntary relationship with the corporate defendant, and then that debt goes unsatisfied and their claim arises. But the key is, before that claim arose, they had a prior relationship and had voluntarily transacted business with them. So the question I posed here, again, a rhetorical question, but I asked, should courts treat certain creditors differently? Should involuntary creditors be treated differently? So these are creditors that are, they're defined as either parties that did deal with the corporation, but did so basically, here, scratch that. So a personal injury victim would be somebody that didn't deal with the corporation prior and did so in this context against their will. Think of an auto accident, or a toxic tort. There are a variety of these personal injury issues that can create a claim from these personal injury individuals, and so those would certainly be considered an involuntary creditor, but also would be, say, trade creditors or certain unsophisticated employees that voluntarily transacted with the corporation, but did so at a big disadvantage in their negotiating position. So, didn't really have an opportunity to obtain guarantees, security interests in collateral for their debts, that were unsophisticated, perhaps weren't able to obtain the credit information with regard to that defendant corporation. So all of those are what we'd consider or involuntary creditors. And what we're seeing throughout the country is that these tort creditors and other involuntary creditors are receiving greater leniency from the courts in veil piercing. And so, we have here kind of a list of some of the policy justifications, but in that second article that I referenced that's going to be published with the University of Maryland's Journal of Business and Technology Law this December, I discuss how in this context, the primary focus of the courts is on these policy justifications for protecting these tort creditors. Okay, so corporations have this incentive to engage in risky behavior, shift costs to unwary third parties. These creditors are unable to adequately protect themselves through these measures that we discussed. Okay, so specifically, how are courts treating tort creditors? Is there a different standard for them? How are they providing this leniency? And what I've found is that the courts aren't applying a different test, but administering the exact same test more leniently. Okay, so we talk about the equitable nature of veil piercing and how it's a weighing of all these different facts and circumstances. So what I'm finding is that that courts are, I guess there's a lower burden of proof for these plaintiffs to satisfy. Perhaps not as rigorous of a showing, of establishing all these different factors. Perhaps less factors are required, or certain factors might be weighed really heavily in favor of the tort plaintiff. So just keep that in mind. This hasn't been addressed in Nebraska, but nearly every court that has been addressing this, and it's it's gaining traction here, but nearly every court that is addressing this is stating tort creditors should have an easier avenue to piercing the veil. So with that, I want to open this up to questions from anyone here in person or reviewing this over webinar. Anything relating to those three veil piercing avenues or any of the related corollary issues. So I'll give you some time here. If you've got one, let me know. If not, again, you've got my email address and my phone number. I'd be happy to talk to you more in depth about some of these issues. Okay. Would a waiver work in an LLC for a tort claim? So that's a good question. If we're talking about a plaintiff signing a waiver before, in essence, transacting business, in that circumstance, if there's a prior relationship with them, just because there's a tort damage doesn't necessarily mean they'd be considered, the involuntary tort creditor. If they had the opportunity or made the voluntary decision to transact with the business and hence signed this waiver, then it would be less likely that they'd be considered that involuntary creditor, if that makes sense. What I'm thinking are the primary example of an involuntary creditor or tort creditor would be those that had no opportunity to sign a waiver. That are just receive that these costs are thrown on them without any knowledge or voluntary consent of their own. This example would be more of a these tort creditor, or this specific tort creditor would have consented to doing this, and again it would be less likely that this leniency would apply. That's what what I would say with regard to with a waiver. So, any other questions? Okay. All right. Well, thank you very much. appreciate your time, and let me know if you have any follow-up questions.